Mr. Chairman, Ranking Member, appreciate the opportunity to have this hearing today and want to thank all of the witnesses for your time and ability to come and speak to us on this important issue. Chief Clem, I'm going to start with you. You served in Border Patrol for over 27 years, and so I know you've had a front row seat to witness the crisis at our southern border and including the spike in arrivals of UACs. I know that you've talked a little bit about this today, but specifically, I believe we need to amend Section 235 of the Trafficking Victims Protection Reauthorization Act of 2008, which is primarily the loophole that is used in our laws to incentivize the illegal immigration of UACs to our southern border. I've been proud to co-sponsor a number of bills that will actually do just that, but it's also worth noting that historically that has been a bipartisan position. June 2014, President Obama sent a letter to congressional leadership asking Congress to amend this act, and even the Washington Post editorial board followed suit in August of 2014. Can you explain to everyone how Section 235 of the TVPRA has incentivized illegal migration of UACs to the southern border, particularly UACs from non-contiguous countries?
I'm going to do my best to recall that specific section, but what I understand, TVPRA, and especially having worked up in Washington, D.C. as the CBP head for the President Obama's executive actions during that time frame when we saw that initial push of UACs in South Texas, TVPRA allows for immediate repatriation to contiguous countries, Mexico and Canada.
Right.
What we need, and when you get to the incentivize, is why are we separating Canada and Mexico from all the other countries, especially those in our hemisphere, Central America, who are generally allies? Why would we not treat the UACs with a rapid repatriation once we've done an initial screening to ensure that they're not, trafficked or not victims of any kind of abuse? But once that cleared, we should treat them and get them back to their home country as quickly as possible, just like we would do with a Canadian national or a Mexican national. I think that would close a loophole and keep the family, because that's oftentimes what's happens. The families are separated before they even get to our border. Come up with a more clear and direct process for someone to lawfully immigrate in the United States versus sending their child in here and then hoping they can reconnect later.
Right. And look, I believe that this creates a safety issue, not only and many times for the lives of the UACs, but also for the American people in many ways. And in June 2024, a report from the House Judiciary Subcommittee on Immigration, Integrity, Security, and Enforcement discussed the fact that at the time, more than 400,000 UACs were released to sponsors by the Biden-Harris administration, which is a 100% increase compared to that of the first Trump administration. Most of them were teenage boys. And if you look at it, nearly 70% of UACs referred to HHS were 15 years of age or older. And in fact, only 19% were actually under the age of 12. The report also found that HHS did not have a policy to refer known gang members to the Justice Department. Additionally, it went on, HHS did not ask UAC's home country and consulates or embassies for their criminal record, despite having the actual ability to do that. And HHS admitted that it did not currently have any secure facilities designed for the secure placement of UACs who posed a danger to themselves or those who had been determined to have a criminal record. So it's worth noting and remembering that the Biden-Harris administration released a 17-year-old MS-13 gang member who had entered the country as a UAC and then went on to sexually assault and murder 20-year-old Kyla Hamilton. For the record, Kyla was an actual legal resident of Maryland, unlike others who we've heard a lot about in the last couple of months. Chief Clem, in my remaining minute here, what reforms do you think are needed within the UAC program to prevent future release of UACs who actually pose a threat to the safety of Americans?
Yeah, we cannot dismiss the fact that many of these kids, as you mentioned, are 15 or older. They are much more, in my opinion, mature than some of the 15-year-olds here in the United States. They've had a hardened life, but they've been exposed to these gangs, and they're willing to do the work of the gangs. And for the safety of other children and for safety of the United States, we have to look at this from a law enforcement perspective first to protect everybody. So I would make sure that we have separate funding and facilities for those that are believed to be criminal, illegal alien children associated with gangs, so we can make sure that they are not put into settings or released to other gang members.
Right.
This is what it's all about. In order to find this bipartisan solution, we have to recognize that there is a criminal element associated with illegally entering the United States, whether you're an adult or a child. Let's focus on that piece to protect everyone involved, most importantly, the American citizens, but the migrants themselves. And then start taking small chunks at the immigration system overall. But we cannot sit there and broad brush and say every child over here and every sponsor is doing this for the right reason, because we've got proof the otherwise. So we have to put law enforcement as a priority first to protect Americans and these children. After that, you got an uphill battle on solving the immigration piece, but it should be a quick solution to target the criminal element involved in all of this.
Thank you so much, Chief Clem, and I'll submit the rest of my questions for the record. Thank you.
So, Chief, the 500,000
During a Senate Judiciary Committee hearing prior to the congressional recess, Senator Katie Britt, Republican Alabama, raised concerns about a loophole in U.S. immigration law that is incentivizing illegal immigration, particularly involving unaccompanied alien children, UACs, at the southern border. The senator proposed amending Section 235 of the Trafficking Victims Protection Reauthorization Act of 2008, TVPRA, a law that, according to Britt, has been exploited to allow more illegal immigration of UACs, especially those from non-contiguous countries. Chief Clem, a former Border Patrol official with over 27 years of experience, testified about the situation, recalling how Section 235 of the TVPRA has created disparities in how UACs are treated based on their country of origin. While children from Mexico and Canada can be rapidly repatriated after a brief screening, UACs from other countries, particularly those in Central America, are not subject to the same expedited process. Clem emphasized that such a policy creates an incentive for families to send children across the border, knowing they will have an extended stay in the U.S. while awaiting asylum hearings. The issue gained national attention in 2014 when a surge of UACs crossed the southern border, with the Obama administration also recognizing the need to amend the TVPRA. Even major news outlets like the Washington Post called for changes, aligning with a bipartisan effort to address this loophole. The primary concern is that without a quicker repatriation process, families continue to send children alone, hoping for eventual reunification, which often separates them from their families before they even reach the border. Senator Britt also referenced a report from the House Judiciary Subcommittee in June 2024 that revealed a dramatic increase in the number of UACs released into the U.S. under the Biden-Harris administration, over 400,000, marking a 100% increase from the first Trump administration. The report also showed troubling statistics, including the fact that many of the UACs were teenage boys, with nearly 70% being 15 years of age or older. Clem added that many of these older UACs have been exposed to gang violence in their home countries and, once in the U.S., may continue their involvement in criminal activity, posing a risk both to themselves and to American citizens. Furthermore, the report noted that the Department of Health and Human Services, HHS, had not established policies to refer known gang members to the Justice Department. HHS had also failed to consult UAC's home countries or consulates about criminal backgrounds, despite having the ability to do so. This lack of oversight and secure facilities for potentially dangerous UACs had led to the release of individuals who could pose a threat to public safety, as illustrated by the case of a 17-year-old MS-13 gang member who was released and later went on to commit violent crimes. In response to these challenges, Chief Clem suggested the need for reforms within the UAC program to ensure that children who pose a criminal threat are placed in secure facilities rather than being released into communities. He advocated for separate funding and resources to handle UACs with criminal backgrounds or ties to gangs, ensuring they do not end up in the same environments as other, non-criminal minors. Clem stressed that a law enforcement-first approach is necessary to protect both American citizens and vulnerable migrants. As the conversation continued, it became clear that while addressing the criminal element is a critical step, broader immigration reform would be required to create a system that can balance security, compassion, and efficiency. Senator Britt's call for amending Section 235 of the TVPRA seeks to close a significant loophole, and by doing so, prevent further exploitation of the system and reduce the risks posed to both immigrants and U.S. citizens.